The Supreme Court making it easier to bring unreasonable force claims against police. The unanimous ruling yesterday now requires more examination when deciding whether they can be tried for unreasonable force. The courts now will no longer make a ruling solely based on the split seconds when an officer fears for their safety. Let's bring in our chief legal analyst, Clive Rhodes, this conversation. Clive, this one right here, it's kind of complicated.
Absolutely complicated. So let's look at what happened in the underlying case. Mr. Barnes, who is now deceased and at the center of his case, dies at a traffic stop. His family brings a lawsuit. What's going on in the case is he's driving a car, a rental car. His girlfriend rented the car. He's going to pick up the children. At some point, they're pulled over because the tags are expired on the rental car. He's unaware of this. At the officers during the stop, at some point, Mr. Barnes goes to drive off. The officer puts his foot on the dashboard and begins to shoot into the vehicle. The family brings a suit. At that point, when we get to the Court of Appeals, the Court of Appeals dismisses the case, specifically saying that they cannot look at anything else at this case except for that brief moment right there in determining if the officer was in reasonable fear of bodily harm. What the court said is a couple of things. You have a court's opinion, you have a court's concurrence, and then you have a court's dissent. I oftentimes talk about the court's dissent. That's the part where I don't agree with what the court is saying, and I'm going to talk about my own rationale of why the court should have went this other way. But concurring opinions are also really, really good. In this situation, you had the court's opinion that dismissed the case. You also had the judge's concurring opinion, right, that, yes, I agree we should dismiss this case. However, if I would have known more facts, if we wouldn't have had to only look at this instant of when they were immediately making this determination, and I had the opportunity to look at the whole picture and understand that, hey, this guy was driving a car, he wasn't trying to do anything crazy, and understood the entire situation, I would have ruled another favor. So now, fast forward to the Supreme Court. The Supreme Court is now saying, I agree with that concurring opinion. That, guess what? If we also could have judges and justices look at the entire picture as opposed to that snapshot of where that officer was in that brief moment and look at the entire stop, look at the entire interaction before the shooting, then we would come to a different rationale. So the court unanimously is saying we need to look at the whole picture, the totality of the circumstances, and not just look at this one instance of right before they pulled the trigger.
So when we talk about the Supreme Court making it easier to bring looking at unreasonable force claims against police as a defense attorney, what stands out to you?
Well, in these types of cases, the biggest thing that stands out is that now you'll have an opportunity to bring a claim. I mean, most of these claims are being barred at the front door. You file a claim, it's instantly getting dismissed for some type of immunity, qualified immunity specifically, or because the threshold for excessive force or unreasonable force is so high that you can't even get to the crux of the argument. In this situation, it's the exact same manner. That if I had an opportunity to look at all of the facts, I would at least been able to rule and allow this case to move forward. And the justices agreed that this is how we should look at cases going forward. This is a great example, not just for criminal defense attorneys, but for civil litigation, wrongful death claims. When a family wants to be able to have their day in court, now they'll be able to have their day. Not saying that it will go in their favor or go against. At least their opportunity to be heard won't be stopped at the door because they weren't able to get over the threshold of maintaining the qualified immunity or that snapshot that they're looking at.
Clive Rhodes, we appreciate your insight. Thank you.